The case is now being recorded. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations, within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good afternoon. Welcome to the Massachusetts Appeals Court on this beautiful July 12th, 2022. This sitting of the Appeals Court is being conducted virtually, but it is being live streamed on our YouTube channel. And I want to welcome everyone who's watching on the YouTube channel. I'm Justice Joseph Didkoff. With me today is Justice Maureen Walsh and Justice Robert Brennan, and we are the panel for this one case. As always is the case, each side will get 15 minutes. A clock will appear in the where the seal is now, and will count down. When it gets down to 0, you may finish your sentence, but that'll be it unless you're answering questions from one of the judges, in which case, please complete your answer. There's no rebuttal. As you may know, we have definitely read the briefs. We have looked at the appendices, so you should feel free to get right into your argument. No need to give us the background. With that, I will call the case for today, 21P 706, Genova versus Cornell. Counselor for defense, whenever you are ready, you may go ahead.
Thank you, Your Honor. First of all, I want to extend my appreciation for conducting at my request the accommodation to do the hearing by Zoom and in the afternoon session. So there are several issues in this case. I won't repeat the briefs. They're there, as you've indicated, Your Honor. But the 12C motion is the first of the issues that I think would be appropriate to address. The 12C motion standard has been not met. There are several issues of fact which would require adjudication at trial and preclude the 12C motion from being granted. If anything, the 12C standard is even a little more severe than the Rule 56 standard because it's on the pleadings. And so therefore, the issues that have been identified that are in dispute are based upon the assumption by the land court judge, Roberts, taking 26 of the undisputed facts right from the Genova's complaint. And the pro se answer of my client before counsel was engaged is one of the more beneficial positions here, because in his own layman way, he attacked and contradicted a lot of those original facts. But in particular, the issue of where the boat and the trailer were located. In the early going, it was all about they were in Smolin Lane. In the appellee's brief, they kind of back off of that a little bit, and they say, well, now, wherever it may have been, they have a right to pass and repass on the roadway. They rightfully backed off on that because my client from day one identified the location of the boat as being on the so-called grassy knoll. The grassy knoll effectively is the beach. The Genova, early on in the case, it never really varied.
Counselor, I was interested in that, but I had trouble. Maybe I'm missing it. I couldn't find any place before the land court where you argued that the trailer was not on Crescent Road. If you argue that below, could you tell me where?
Well, first of all, Your Honor, we make a big distinction between Crescent Road and Smolin Lane. One of the pieces that is part of my presentation is they're not the same thing. But in Cornell's original pro se answer, he addressed the fact that the boat and trailer were on the grassy knoll. He put that into dispute with his pro se answer. And early on,
where did you argue that in opposing the motion for judgment on the pleadings?
We argued it in regard to the validity of the 12C motion, that it was one of several disputed issues in the case. It did come up after the map was done and after counsel for the appellee identified the three areas, 1, 2, and 3, and the court determined that only the issue that was relevant, the area that was relevant, was issue 1, which is Snowden Lane. The court specifically excluded the area 2, did not go there, did not go to area 3, which was the pond bed under the dock. And so as a result,
let me ask you this. If the trailer is not on Crescent Road, then what's the problem with the injunction? It only bars you from blocking Crescent Road. If the trailer is not on Crescent Road, then the injunction isn't affecting your client at all.
Right. And after all the dust settled on it and the map was drawn by Randy Parker, and the decision was finalized by the court's judgment, I will agree, Your Honor, that the judgment actually becomes moot as a practical matter because it does not affect where the boat and trailer were located. However, that being said, that dovetails into my Rule 12b6 and 7 motions that in effect, the complaint should have been dismissed because it didn't have vitality at all in terms of the location of the boats and trailer. So I do agree with you, Your Honor, that is the case. We filed the appeal for a variety of reasons, including the lack of the counterclaim being allowed, the amended counterclaim by the land court. So as a practical matter, we agree that the final judgment really has no practical effect. And Mr. Cornell could put the boat and trailer right back in the grassy knoll area tomorrow. And yet we didn't want to encourage the fact that they might come back in with another preliminary and the issue would need to be adjudicated all over again. So rather than just say, you know, in effect, Your Honor, we won the case. The judgment against us actually was a victory for Cornell, which it was in terms of the specifics of the preliminary and ultimate judgment. The issues here, the problem in this case is the fact that the underlying merits were a substantial portion of all of the proceedings, all of them. And so we got into all the merits, even though the issues were based on a 12C motion. Ultimately, they were based upon the amended counterclaim, which the court denied because of standing. So it was our opportunity to say, listen, let's settle the issue of standing. Let's settle the issue that the counterclaim was erroneously denied. After all, it was only a counterclaim. We didn't preclude some further proceeding occurring. We just wanted to file a counterclaim and then take matters from there. But I suspect that even if the counterclaim were allowed, that they still wouldn't have met the standard under 56, even if they brought a motion there. There was indeed an actual controversy. Everyone agreed on that. And so as a result, we believe that even though the original decision would really have no practical effect on us, we're looking for the court to preserve the counterclaim so we can go forward on the counterclaim based upon the underlying issues of the ownership of the pond, the ownership of the roadway, the derelict fee statute effectively.
Oh, wait, let me make sure I understand you. Are you saying you're dropping your appeal of the injunction?
No, I'm suggesting there's some practical benefit because what Judge Roberts did is she indicated that, look, you need standing. So why don't you go out and bring a separate proceeding against both the Commonwealth and the heirs of Kendrick and Hall. And so we took that into account. But this court's decision in this ruling that you would decide here will be ample benefit to that ultimate decision that we would have in bringing the standing issue before Kendrick Hall and the Commonwealth of Massachusetts. So that as a result, the value of this case being decided by the appeals court is not moot in any respect in those regards. And we would like to have the counterclaim, this revised counterclaim, allowed so we can move forward on that issue in the land court. That's the ultimate objective. So in judicial efficiency, we wanted to proceed, even though the practical benefit of the injunction is basically non-existent. So let me speak.
Mr. Craig, can I ask you a question? I may be way off base, so feel free to tell me. But am I understanding your argument that that there's no easement to the pond? It doesn't extend to the pond. Is that what you're saying? It goes halfway over the land side of the road. Can you all hear me?
I'm sorry. I can't hear you. I just missed that last.
Yep. Is your argument that the easement, the Genova's easement, does not extend to the pond? Doesn't go past to the pondward side, if you will, of the road? Is that part of it?
That's part of it. We don't believe that Genova has any easement whatsoever by estoppel or otherwise. And I addressed that issue in my briefs. And the problem with the land court decision is they relied upon this court's determination in Smolin versus Genova. And that case is applicable in part, but it's distinguishable. And I addressed that in my brief. And it goes to the goose and gander argument that they didn't think much about, which I thought was pretty insightful. The land court said that Genova doesn't need to bring in indispensable parties to establish their easement. This court said that you need to do that. And the court in Smolin Genova said you can't grant. I made a point to say at page 111 of the Smolin Beach decision, which, by the way, I have historical reference to that case as well. I was co-counsel on that case. And so as a result, the court said we can't go along with the Superior Court judgment because necessary parties were not included. Nobody can claim an easement in that roadway. And so as a result, what happened here, the land court said, well, we're relying on Smolin Genova, but we're allowing Genova in this case to have it without the necessary party inclusion. So as a result, unless necessary, the Genova should have brought in the necessary parties to get an easement over Smolin Lane. And again, the distinctions between Smolin Lane and Crescent sidetracked by Genova's brief and by the court. Those are clearly distinguishable issues. And I point out on
how do we figure out what Smolin Lane and Crescent Road? Because everything I looked at, they look like the same place to me. So
they're not.
Okay, so
they're not.
What's
Historically,
the best place to look to figure out what is where and which one is what one?
Right, right. They make a point by saying that Crescent is the old name that included the area that's now defined as Smolin Beach. Okay, and we don't dispute that. There's nothing in a name, but the distinguishing characteristics of Smolin Beach versus Crescent is that Smolin Beach is in front of Cornell's property. It's not in front of Genova's property. Genova's diagonally across the street. What the appeals court did is they used the Genova Smolin Beach appeals court decision to say, well, they got an easement over that whole right of way. That flies in the face of this court's decision in Smolin Beach, Genova. Unless they bring in necessary parties, they don't have an easement at all because those necessary parties are omitted from their determination. Not to mention the fact that it's an easement by estoppel. And so it's still an implied easement, no matter how you slice it and dice it. So as a result, the differences are significant. In this court's decision in Smolin Genova, what they determined is that Genova and the Smolin Beach Association had derelict rights to halfway into the roadway. They didn't go beyond halfway in the roadway because there was no lots on the pondwood side of Crescent Road. There was just the pond. And as a result, Kendrick and Hall owned the pond, not by reservation of deed, not by description. They owned it because of the fact that they didn't give away their rights. They own a section of Island Pond. Whether they owned to the center of the pond or to the center of the cove, they owned that in front of that Crescent Road on the pondwood side. This is different. Cornell owns the property on the water. One of the 5 distinguishing characteristics I point out on page 21 of my brief is that Cornell owns pondwood property. There's unlike the Smolin Beach Genova case, he owns the property in front of him. Under any construction, Your Honor, whether it's a private pond or a great private pond, as the Superior Court said, and even this court agreed in Small and Beach case, it's a great private pond. Or if it's a Chapter 91 pond.
I don't
Either
think
way.
we said that. I think we said that that wasn't being appealed here. The rights of the Commonwealth to this pond weren't adjudicated by us or by anyone.
That's true, but in the Brook Farm case, as well as in the Genova Small and Beach case, this court said between the parties that could make a determination that it was a great private pond, just between the parties. They didn't adjudicate the ultimate ownership of it. And so that's all we're asking for, is an adjudication between the parties. The difference doesn't affect Cornell's ownership of the pond bed in front of him. It does affect how far it goes. If it's a great pond, it only goes to the low water mark. If it's a private pond, it goes to the center of the cove. And interestingly enough, no one in the Small and Beach Genova case, my deceased brother, Lee Alfieri, nor attorney for Genova at the time, nobody discussed the issue of whether it was a long lake method pond or not. That issue only determines how far the rights of Cornell go into the pond. That's all it does. It's not on the website. It isn't a great pond, Chapter 91, and the private ownership predated the colonial statute of 1641. So as a result of all that, it is indeed a private pond. We're going to separately proceed to adjudicate the rights against the Commonwealth, who's agreed to accept service and be a friend to the case when it comes around, and also the heirs of Kendrick and Hall. But that's the ultimate issue of the ownership of the pond. Cornell owns the area that Genova's dock is on under either method. And so as a result, the counterclaim should have been allowed. The necessary parties as it related to derelict fee rights. This court clearly said, look, you need necessary parties to get the pond.
I think time's expired. I think unless there's any other questions from my colleagues, we'll have to leave it at that. We have your briefs, and you don't waive anything by not reaching it. Everything in your briefs are preserved.
Thank you, Your Honor.
Thank you. So we will now turn to counsel for the plaintiff. Attorney, counsel, whenever you're ready.
Thank you. Good afternoon, Justices Ditkoff, Walsh, and Brennan. May it please the court, my name is Robert Krause on behalf of the Genovas. I have been litigating the Genova's property rights in and around this area for going on 18 years. I think this is 17th year. The dispute with Small and Beach started in 2004, litigation ensued in 2005. And notwithstanding the fact that my clients are fit, they are fatigued by enduring continuous fights over their articulated, adjudicated rights to their property. This matter comes before you as a result of the appeal of my brother on Judge Roberts' decision, a land court from January of 21. It's in the record. I'm sure you've read it. It's well written, it's thorough, it's thoughtful, and it's the law of this case. And I'm asking you on behalf of the Genovas to uphold it in all regards. Essentially what Judge Roberts said was, Mr. Cornell can litigate this all he wants, but he's got to get the right parties. He's got to get the indispensable, necessary parties. Island Pond is a unique being in the sense that your decision in 2018, 94 Mass Appeals Court 106, took the position, because it wasn't disputed, that Island Pond was a private pond, meaning that Kendrick and Hall owned the pond bed and the other side of Crescent Road, Small and Lane. And I'll tell you, as Judge Roberts found and the appeals court found in 18, it's one and the same. If you look at the 1927 plan, there's one lane, there's one road. It's not distinguishable. My brother hasn't cited any law, engineering, any foundation for arguing that they're not one and the same. It's a red herring. So what Judge Roberts indicated is go find the right parties, because if it's a private pond, then Kendrick and Hall own on the other side of the Genovas and the pond bed. If it's a public great pond, that it's the Commonwealth. Neither of those parties is involved in this litigation. Now, my brother seeks to move to dismiss the Genova's claims because we did not add indispensable parties. Another red herring. Why? Because in the Small and Beach Association Genova case, we litigated our rights to that road in front of us and the easement to and from. Judge Roberts, in her decision, uses a phrase that is often unheard of by me, at least in my practice, but black letter law. Those are the words that she uses with respect to the easement by estoppel that the Genovas have. And in fact, in her decision in 2 places, she indicates that the easement by over Crescent Road, Small Lane is not contested either by Cornell or us. Why? Because it's so. It's black letter law. We have an estoppel by or an easement by estoppel. And what she says is there are 2 foundations, 2 standards by which a party can have easement by estoppel. Either it's use, but more particularly here, it's a deeded right on a plan. And she makes it very clear that there is no dispute with respect to the easements that the Genovas have. As she says, even if Cornell is found to own the fee, as he's arguing, even if he owns it, he can't stop the Genovas going to and from their dock. That's in her decision. And she takes the position most fairly on behalf of the Cornells. As a result of that easement, which she says is, I can't hear you, Justice.
Sorry, I'm muted. It's muted. I unmuted, then muted myself in one fell swoop.
Beg your pardon, Your Honor, I didn't hear you.
That was my fault, yes, because I muted myself. Sorry about that. So can you just explain again why your client's easement goes beyond the midpoint of that road?
Yes, Your Honor. As you can see in the decision of Judge Roberts, and it's most particularly in the pages 58 through 60, there's an articulation of the plan that is associated with the easements, and they've been crossing and recrossing under the decision from 18 since they've owned it since 1975. They've been going to and from their property to the waterfront since 75. In fact, in the underlying case in 18, the appeals court overturned the Unit B owner's rights to that easement because they were not in the litigation. What the court said in 18 was the Genovas and Small Beach have a right, an easement to and from the pond, which is right in front. Their lots are on Crescent Road, Small Lane, and they have the right to cross and recross to the pond, but they don't own on the other side of Crescent Road, Small Lane because of the derelict fee statute. And the only people that own that are either the Commonwealth, if it's a public pond, or it's going to be Kendrick and Hall if it's a private great pond. What this court, Judge Roberts, said is pretty clear that the Genovas and Smallland don't own it. So what she said to Cornell in this litigation, and there are extensive arguments, the transcripts of which are in the record. I would suggest to you that if you wanted to read the transcripts from the October 7th argument and the December 9th argument, they're found in the supplemental index, the October 7th starting at page 77 and the December 9th starting at page 287. And what Judge Roberts said is, I'm just dismissing this without prejudice. You can litigate this all you wish. And as Attorney Correa said, it sounds like he's going to be litigating it. It's pretty clear under the 4 motions that you have in front of you, 2 are an abuse of discretion. The Rule 64, there's nothing unique, nothing unusual. Judge Roberts is uniquely qualified to adjudicate rights on easements in the land court private practice. There is no abuse of discretion. The motion to dismiss was lack of standing. Indispensable parties, the futility of allowing the counterclaim because you don't have the right parties. The judgment on the pleadings is, again, based upon your decision in 18 and Judge Roberts' clear reading and unmistakable interpretation of the underlying case from 18, that the Genovas have an easement, it's black letter law, and as a consequence, Cornell and his privies cannot block that area, cannot block that access. If
Counselor,
Mr.
Counselor,
Yes, Your Honor. Yes,
one thing
Justice.
that your friend says, I don't think until his reply brief, but is that he wasn't blocking Crescent Road. And your complaint doesn't actually say that the boat trailer was on Crescent Road. It just says it was between the Genova property and Island Pond.
Your Honor, our Justice Ditkoff, we take the position that it was blocking our access and that it was in the Crescent Road area where their dock was. By all accounts, by all plans, as you can see from the 2018 decision, directly across from the Genovas is the dock where in 2011, they got a full permit from the town of Plymouth to locate their dock, and they've been moving it back and forth. Remember, this was a hearing before the Conservation Commission in 2011. Mr. Cornell was there and did not appeal it, did not oppose it. So we've been using it continually way before 2011, but where it's located now, 2011. This last year, there were confrontations. He chained a boat and a trailer and other accoutrements so that the dock could not be placed in the water where historically the Genovas have had access to Island Pond.
Okay, but this judgment says that Mr. Cornell was obstructing Crescent Road.
Yes, yes,
So
Justice.
where is that accepted in the pleadings? Where is that as a matter of pleading?
It was in our complaint and the affidavit submitted, Your Honor, and I think it's acknowledged by Judge Roberts in her decision where she cites to the facts and that, if you will, paragraph, you see this on paragraph 23 of her findings, which she takes from the verified complaint, paragraph 34.
She definitely says that, but the question is that in the accepted pleadings? Because paragraph 30, is it 34?
Yeah, 34, 35, and thereafter, Justice Ditkoff. Yes. The essence of our argument in the pleadings, and it's uncontested, is that Cornell blocked access by impeding our easement rights over Crescent Road, Small Lane, and to the pond bed. As I think Judge Roberts stated in her decision, held in her decision, and again, interpreting the 18 decision,
Well, so
it's not for Cornell to block or move us.
I get that, but so 33, in paragraph 33 of your complaint,
Yes,
Cornell parked a boat trailer and speedboat from the Genova property in Island Pond.
yep.
But I don't see where it says that it was on Crescent Road.
If you look at paragraph 43,
43?
Your Honor, in May of 2020, Mr. Cornell moved the boat trailer and canoe to the shoreline of the pond. So he continued to encroach further and further into the area where we had historically since 11 placed our dock.
Okay, but as long as he's not blocking Crescent Road, I don't. If your complaint is that he's blocking, you don't have any right to the dock that we can adjudicate. But he can't block Crescent Road, and he doesn't have any right to keep you out of the null without putting in the other parties.
That's right.
Looking at paragraph 35, right? I'm looking at paragraph 35 of the verified complaint.
Yes, yes, Justice Walsh. Yeah. The following spring, Cornell chained a canoe behind the boat trailer and speedboat. So essentially, and 34 is he kept the boat trailer and speedboat on the Cornell near his house when it not in the water. Then he moved it and he essentially blocked our access
On
to
the Crescent Road.
to
side.
Crescent Road, Small Lane, which again are one and the same. Justice Ditkoff, Justice Walsh.
I see. My colleague shows me. Yes, Cornell admits there was also a canoe that was located on Crescent Road. It's in the answer.
Yes. So justices, again, Justice Ditkoff, I agree with you. Again, I think that the decision of Judge Roberts is very limited and strictly on the foundation of the 18 case and what the law is. Again, we're not asking the court to terminate Mr. Cornell's rights in total. All we're asking is you uphold Judge Roberts because we think she got it right in all respects. The motion to dismiss, because it's been articulated and adjudicated in the lower court. The motion to amend, which was futile for failure to bring in indispensable parties. The judgment on the pleading because of the black letter law, our easements rights to and from. We're not asking to impede on anyone else's property, whether the Knoll or Mr. Cornell. But what this court said, what Judge Roberts said, based upon what this court said in 18 is, he cannot block our access. And if he wants to try that, he can litigate and find the Kendrick and Hall successors or deal with the Commonwealth of Massachusetts. It's one or the other. But as Judge Roberts said, we know it's not the Genovas. They're not the right parties, but he cannot interfere with our rights. I respectfully request on behalf of my clients, who again have appeared several times in front of this august court, the SJC, and multiple days in hearing and trial, and countless motions. It has one of the largest dockets in Plymouth County, that this end. If my brother sees so fit to pursue other claims against the Commonwealth and Kendrick and Hall, so be it. But this should end and the court should uphold Judge Roberts' decision. Thank you very much, justices, for your time and patience with me.
All right. Yeah, all right. Thank you both for this very interesting case as we continue this ongoing litigation. I'd also like to thank our clerk today and thank Joe Stanton and his entire staff for setting up these video conferences and allowing them to go so smoothly. And thank, of course, both of you for your presentation today. And with that, we will stand adjourned until July 14th, 9:30 a.m. in person in the